My name is Joy, and I have a CPS case, and Mr. Davis is my lawyer. I found him in the internet when I was searching because when my son got taken away by CPS, and every time I go to Mr. Davis, it always make me feel better when I go home. He helped me a lot. Before I only have 2 hours visitation. Now they give me 3 times a week and 2 hours.
Good morning. This is Attorney Vince Davis. Welcome to CPS Office Hours. Today we're going to dissect one of the most commonly misunderstood and most dangerously used allegations in all of CPS: failure to protect. This allegation is used to destroy families, and it destroys cases. It takes children away. It terminates parental rights. Even if you've never laid a hand on your child, they can take your child with this allegation: failure to protect. In this 30-minute live stream, I'm going to walk you through what failure to protect means in California, how CPS uses it, and most importantly, how to defend against it at every stage of the case. If you're not in California, it probably is similar, but check with your attorney. If you're facing this allegation right now, call my office immediately. This is not the kind of case you fight alone. Part 1, what is failure to protect? The definition in California Welfare and Institutions Code, section B300B1, quote, the child has suffered, or there is a substantial risk that the child will suffer serious physical harm or illness as a result of the failure or inability of his or her parent to adequately supervise or protect the child. Now, this includes failing to stop someone else from abusing the child. It includes exposing the child to unsafe people or environments. It includes ignoring warning signs. It includes not reporting child abuse. The key point is, you don't have to be the abuser. CPS uses this when they can't prove that you have abused the child, but want the child removed from your custody. I was talking to someone just the other day. She was a mother, and she and the father were divorced. And the family court ordered that the father have visitation every other weekend. Turns out, allegedly, the father was abusing the children on the weekends when he had the child or had the children. Mother didn't know about it. Well, when they took the children, they alleged that the mother failed to protect. She didn't even know what the father was doing on his visitation. That's how far CPS tries to take these cases with this failure to protect stuff. All right, for part 2, the first contact, pre-detention hearing stage. It's my advice that you never admit guilt. It's my advice, don't speculate and don't try to explain. Let your attorney speak for you. It's my advice that CPS will use your statements to argue, quote, you knew or should have known, unquote. I think this is an action plan that you should consider after speaking with an attorney. Immediately remove the alleged abuser from the home. Schedule your own assessments with therapy, parenting, DV education, whatever it is. These are not admissions of guilt. Hire an experienced attorney. Call me. My number's right here on the screen. Part 3, strategy at the detention hearing. File a declaration denying the knowledge or control, if true. Offer a safety plan and voluntary services. Ask for relative placement or placement with a close family friend. Anything but foster care. Consider this evidence that you might want to submit at the detention hearing. Police reports, medical reports, texts or emails showing unawareness of the abuse by the person that's being accused of actually abusing the child, and show immediate steps that you've taken. Move out with the child, restraining orders that you've tried to get, enrollments in other types of classes like therapy, parenting classes, that type of thing. Talk to your attorney about what type of services that you might want to take or enroll in to alleviate the problem. Just yesterday, I told a woman who was facing this exact charge that she should take the children and move into a domestic violence shelter where she and the children could live. Now, I can't tell you all of the facts, it gets too complicated, but this would show the judge at the detention hearing that she's taken immediate steps to alleviate the situation or the danger of the father coming and getting close to the children or having contact with the children. She is basically, if she moves into the shelter with the children, she's alleviating the danger. Part 4, the jurisdiction hearing, breaking CPS's narrative. You have to challenge the quote, knew or should have known language. How do they prove that you should have known something? That's a pretty tall task. But sometimes it's just accepted that you knew or should have known. It was happening, therefore, you should have known. Argue that CPS is relying on hindsight, not the facts as they were when this was happening. You may consider, after talking to your attorney, you might want to file a motion to strike vague or unsupported language in the petition. You can file those types of motion under a case called In Re Troy D, Troyd. Talk to your attorney about that. And you also want to cross-examine targets, the social worker who made these assumptions. Generally, not all the time, but generally it's my practice, you always want to cross-examine the social worker who wrote the reports. You want to also cross-examine the CPS experts who had no contact with the child. You know, sometimes CPS writes reports and they quote experts who've never even seen the child or never even interviewed the child. All right. Part 5. Disposition hearing. Protecting your parental rights. I often say that the disposition hearing is the most important hearing in the CPS scheme. All right? Most important hearing. If the jurisdiction hearing is sustained, i.e., found to be true, fight to stay in the game. Propose a tailored reunification plan or family maintenance plan. Ask for an individualized case plan. The elements of that case plan could include DV or domestic violence education, non-offending parent therapy, drug testing, sexual abuse counseling, sexual abuse awareness counseling, domestic violence awareness counseling, physical abuse awareness counseling. Remember, in most of these cases, your failure to protect meant that you weren't the abuser. You just knew or, quote, should have known. And in my mind, in most of these cases, that's simply not enough at the disposition hearing for you to lose your child. Pro tip: document every service you complete or begin and submit monthly updates to the court and or to the social worker. Part 6. Consider using expert testimony. You have to talk to your attorney about this. You can use a domestic violence expert who can explain the dynamics of fear, control, and trauma, and how you can eliminate that from your life. You might want to consider using a parenting psychologist to show insight, education, and your changed behavior. Here's one that I have actually seen used. I've never used it myself, but I have seen it used quite effectively. A cultural expert who can explain misinterpretations of family roles. Now, I saw this used in a case where the family was Indian, Asian Indian, and the expert really explained to the court, to the judge, certain cultural things in the Indian culture. And I think it really had an effect on the judge and the judge's final decision. So consider that, because most people come from different cultural backgrounds and they have different cultural things with respect to children, family, how children are raised. So consider that. The purpose is to shift the court's understanding of your level of risk. Part 7, rewriting the narrative through action. Enroll in services before they've been ordered by the judge. These are not admissions of guilt. Secure a stable home and work schedule. File 388 motions to request increased visitation or reunification based on your progress. Be proactive, not reactive. That's important. Proactive, not reactive. Part 8. Managing the child's attorney. Determine if they've spoken to the child. Present your progress reports to the child's attorney directly. You can do that through your attorney. Your attorney can just email that information to the child's attorney. Ask for their support in expanded visitation or return of the child. Now, you wouldn't want to do that directly to the child's attorney. You would want to do that through your own attorney. Most children's attorney know that they shouldn't be talking to you as a parent because it would be illegal for them to communicate with you because you have an attorney, unless your attorney gave that permission in writing. So remind your attorney or request of your attorney to send your progress reports directly to the child's attorney. Sometimes children's attorneys feel that they are left out of the loop when your attorney speaks directly to the county council, the social worker's attorney. And in a lot of instances, I try to remember to include all my communications to the county council and include the minor's attorney, because I don't want them to feel like they're being left out of the loop and that they mean nothing to the case, because they do. They have an important role in the case, and the court listens to what they have to say, their opinion. Request that they submit their own report outlining the child's bond with you. You know, a lot of children's attorneys are very independent. And if they believe that you have some type of emotional, psychological bond with you, when they go to court, they may argue for you and argue that the child should be returned to you, or argue that your parental rights should be terminated. So keep them in the loop. Part 9, winning at a review hearing. Remember, you have review hearings every 6 months, 6-month review, 12-month review. Sometimes you have that 18-month review. And in rare cases, you'll have that 24-month review. Highlight your compliance with the case plan at every review hearing. You and your attorney want to submit progress letters for service providers or from service providers. You want to have updated declarations. You want to have supportive documentation from your community. Remember, this language works: substantial compliance, proactive parent, family stability. Part 10, preparing for a 366.26 hearing, the dreaded .26 hearing, also known as the selection and implementation hearing, also known as the death penalty for CPS cases, when it's almost too late. File last-minute 388 petitions with expert declarations. Argue strong parental bonds. That is the primary exception to win and defeat a 366.26 hearing. Request legal guardianship in the alternative of the termination of your parental rights. But don't wait. The 26 is hard to beat, but it's not impossible. Failure to protect is how CPS wins a lot of cases where they can't prove that you abused the child. But you can prove if you act fast, gather proof, and file the right motions. Call me today. Let's defend your rights together and get your child back. If you have any questions, drop them in the chat. I'm taking Q&A right now for the rest of the live stream. We got about 15 minutes. Let me look at the questions. All right, Debbie from YouTube. Morning. Good morning, Debbie. Debbie says Medicine Lodge, Kansas. Margaret King, a member of my YouTube channel. Margaret says CPS is using all the times that I call for help from law enforcement or an ambulance to get the offending parent to the hospital. The system failed us all the way around. Cynthia says, good morning, Attorney Vincent. When I came back home yesterday night, I found in the mailbox an important piece of mail. I lost my place. Important piece of mail of our case, but it is in English, and I need your help, please. Cynthia, just give me a call, 888-888-6582. Cynthia on YouTube goes on to say, I need to go to your office for you and Pilar to help me. Do you have court today? Can you please help? I'm going to the office. Yes, please come to the office. Cynthia, I do have court. I won't be there, but Pilar will be there and she will help you. Okay, I don't see any more questions. No questions today. All right. So that'll be it for today. I'll see everyone tomorrow at 6:30 a.m. Pacific Standard Time for my standard office hours. Bye-bye.
I recommended people that have a CPS case contact Vincent Davis. It's gonna help you a lot. Thank you.